Welcome to your ultimate guide to the world of intellectual property law. Whether you are an inventor, entrepreneur, or simply curious about how ideas become protected assets, this podcast is for you. Each episode, Spoor and Fisher partner and legal professor, Professor John McKnight, will explore the intricacies of IP and delve into specific disciplines to guide you through patents, trademarks, copyright, and more.
Okay, let's have a drill down into registered designs. Okay, so that's what a registered design looks like. And you can see that it gives the date of application and the number, and it gives you a little idea of what the design relates to. In this case, we're sticking with the multi-tool, and this design relates to a folding multi-purpose hand tool. So South African law is unique. Most countries around the world have their own design law, which are largely harmonized, but South Africa is a little out of kilter with the rest of the world in that we have two types of designs. We have aesthetic and we have functional designs. So an aesthetic design is a design applied to any article, whether for the pattern or the shape or the ornamentation thereof, having features which appeal to and judged solely by the eye. And we have functional designs. A design applied to any article, whether for the pattern or the shape or the configuration thereof, having features which are necessitated by the function which the article is designed to be applied to or is to perform. So you can see aesthetic designs, they have shape, configuration, ornamentation, pattern, whereas a functional design only has pattern, shape, and configuration, no ornamentation on a functional design. So the requirements to get a design is that they must be new and original in the case of an aesthetic design, and new or not commonplace in the art in the case of a functional design. Again, we have absolute novelty in terms of a aesthetic design, but there's a little more latitude for functional designs. There is a 6-month grace period for designs. There are no grace periods for patents, but designs, there is a 6-month grace period. So in other words, you can make your design, release it to the market, having not filed for a design application. And then as long as you're in within 6 months, you can say, actually, you know what? This is a remarkable success. I want a monopoly on this. And then you can go and file. And as long as you were the guy who released it and you do it within 6 months, you can take advantage of this grace period and you still comply with the novelty requirements. Okay, the design must be applied to the article produced by an industrial process. So that means they must pump them out, right? It can't be like a statue or just a couple of them which are put together. That would form into the realm of copyright, which we'll explore in greater detail later. But so it must be an industrial process to make these things, and protects the appearance of the article regardless of the aesthetic merit. So a bit like copyright there. The term of a design is 15 years in the case of an aesthetic design, 10 years in the case of a functional design, and of course that must be weighed up against a patent, which is 20 years, right? And the proprietor has the right to exclude others from making, using, disposing of, and importing into the RSA. So it's slightly different from patents there, which is an important distinction.
You are a leader, a visionary. You embrace technology to develop cutting-edge solutions. You are original and innovative. You imagine. Trailblazing is often a lonely path, but we see the extraordinary in what you do. When it comes to understanding and protecting your intellectual property, your journey is our journey. Visit our website at spoor.com and discover how we can protect what is uniquely yours. Spoor and Fisher. Create it. Own it.